Welcome, everyone, to the Committee on Judiciary and Hawaiian Affairs. It is Wednesday, March 29th at 2 p.m. We're in conference room 325 here at the State Capitol. Welcome, everyone. Thanks for being here in person and on Zoom. My name is David Tarnas, Chair of the committee, and we have Vice Chair Greg Takayama and Member Representative Kanani Souza here today. The rest will join us presently. If you're testifying today, I'd appreciate it if you keep your testimony to just a couple of minutes, and I'll ask you to summarize at that point so we have opportunity to ask questions and get through all of our bills on the agenda. And if you're testifying via Zoom, turn your camera and microphone on only during the time you're testifying, and then keep it off the rest of the time. That'd be great. And if you're using a background, don't use a copyrighted image or trademarked image, because that gets us kicked off of YouTube. So if you could help us out by just avoiding copyrighted or trademarked images in your background, that'd be great. And if everyone would be kind enough to, if you want to disagree, just don't be disagreeable. And we'll all get along. We're all here to do what's in the best interest of the people of the state. So we're allies in that regard. So let's work together to do our best. Let's go ahead and get started. Our first measure on the agenda today is Senate Bill 966 relating to disposal of solid waste. This measure subjects to forfeiture any vehicle used in the commission of felony disposal of solid waste or petty misdemeanor disposal of solid waste. First up, we have testimony and support from the Department of Health. Next, we have testimony and support from the Environmental Caucus of the Democratic Party of Hawaii, and testimony in opposition from Ruta Jordans. Is there anyone else here or on Zoom wishing to testify on this matter? Mr. Ted Bolins, please proceed.
Thank you, Chair Tarnas, Vice Chair Takayama, members. Ted Bolin on behalf of the Hawaii Reef and Ocean Coalition in strong support of this measure. I worked for 15 years doing water pollution with the Department of Health, and I know that solid waste disposal can be a serious water pollution issue, a serious environmental issue, and I think that it's appropriate where vehicles are frequently used in disposal, especially of construction and demolition debris, that forfeiture really is an appropriate remedy for the nature of the offense, as well as the other provisions of this bill. So the Hawaii Reef and Ocean Coalition is in strong support, and I urge you to pass, and thank you for the opportunity to testify.
Thank you very much. Anyone else wishing to testify on this measure? If not, questions, members? Seeing none, we'll move on. Thank you. Next, we have Senate Bill 388 relating to waste disposal facilities. This measure prohibits the construction, modification, or expansion of any waste or disposal facility for hazardous waste or solid waste on land that is near or above a significant aquifer as determined by the Department of Health in consultation with the Commission on Water Resource Management. First up, we have testimony with comments from the Department of Health. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair Tarnas, committee members, Takayama and Souza. My name is Gaudencio Lopez. I'm with the Department of Health Safe Drinking Water Branch. I'm joined here today with Glen High, a Solid Hazardous Waste Branch. The department stands behind its comments and will be available if there are any questions.
Actually, if you could be so kind as to tell people who are listening and watching who haven't read your testimony, just give us some of the highlights, your main point of your testimony.
The department had evaluated from a statewide perspective what that impact could be. There's a figure in our comments demonstrating that it would be very difficult to site a landfill above what could be considered a significant aquifer. And what we do ask the definition of citing a landfill below a significant aquifer, because there is the possibility of having geological features above that could buffer any impacts that landfill could have. And so we're trying to strike that balance between being protective of drinking water sources and also having very solid waste management practices that is practical and affordable for the public. The threat of dumping is real, and it's typically a cost-saving measure. So without a landfill, and if you had to talk about exporting to the mainland or other alternative means, it could raise the costs, and it could impact communities that can't afford that, resulting in issues with environmental justice, as well as the issues of promoting dumping. So that's all I have.
Thank you. And if I could just quote a couple things which are very salient in your testimony. It says, as such, the siting of a landfill on the island of Oahu, when all restrictions are applied, would be nearly impossible should this measure pass.
Yes, if you look at, if you combine this act with Act 73, it really narrows that gap. Most of the available landfill sites above the no-pass zone, the county's no-pass zone, are located in the central part above significant aquifers. And as a result, that would put a stop to that. There are some locations below that's possible, but it all depends on how this bill is, there are geological features below the no-pass zone that could make it possible, but if you strictly define that no landfill above a significant aquifer, then if you talk about the deep basal aquifer, thousands of feet below, then that would put a stop to any possible landfill options for the state.
Okay, thank you very much. Appreciate that.
Thank you.
Information. Next, we have testimony from the Board of Water Supply. Welcome. Please proceed.
Chair Tarnas, Vice Chair Takayama, members. My name is Kathy Mitchell. I'm with the Board of Water Supply, and we stand in strong support of Senate Bill 388 HD1. Would you like me to?
Briefly summarize.
Yes. The U.S. Environmental Protection Agency and the U.S. Geological Survey, they have determined that all landfills do fail and can release harmful substances that can contaminate our drinking water aquifers and the environment. We have only one aquifer, and many areas of the aquifer are threatened by the Red Hill fuel release possibility anytime soon. The AFFF, that's aqueous fire foam, it contains PFAS. And then we have the landfill. We need to protect our environment. Thank you.
Thank you very much, Ms. Mitchell. Next, we have testimony in opposition from Ramsey Mansour, the County of Hawaii Department of Environmental Management. Let me briefly state some highlights. It says, we cannot support this bill. If approved, it would result in unintended consequences. We urge you to defer this bill until further scientific data becomes available. And they say that adequate engineering and design technology exists to prevent contamination of groundwater in compliance with the Clean Water Act. This bill, which is rightfully driven because of the Red Hill fuel storage leaks, should not become law without scientific evidence to support it. So they oppose this measure. Next, we have testimony with comments from the County of Kauai. Next, testimony with comments from City and County of Honolulu, Roger Babcock. Next, comments from the County of Maui. Next, support testimony from Melody Aduha. Testimony and support from Hawaii Farm Bureau. Testimony and support from the Land Use Research Foundation of Hawaii, and testimony and support from the Hawaii Firefighters Association. From testimony and support from B.A. McClintock, Mike Keto, Victor Kimura, Sherry Pollack, and testimony in opposition from Georgine Adams from Hawaii Island. Is there anyone else here wishing to testify on HB 388? If not, questions, members? Any questions? Seeing none, we'll move on. Thank you. Senate Bill 1417 relating to climate change. This measure requires the Hawaii Community Development Authority to consider the impacts of climate change, sea level rise, and climate resilient development in the design and siting of buildings in the Kaka'ako and Kalailoa community development districts. On this, we have testimony and support from the Office of Planning and Sustainable Development. Welcome. The floor is yours. Please proceed.
Thank you, Chair Tarnas, Vice Chair Takayama, members of the committee. This is Justine Nihipali. I'm with the Office of Planning and Sustainable Development. We stand on our testimony in support. Thank you.
Could you just briefly describe why you think it's a good bill?
Sure. Its efforts really for the state to strengthen its resilience to climate change for the areas along the shoreline.
Great. If you could hang out for questions, that'd be great. Thanks. Next, we have testimony in support from the Hawaii Community Development Authority. Mr. Nakamoto? Nope. Testimony in,
Hi.
oh, you are here. There you are.
Good afternoon,
I
Chair.
was looking up on the screen. You're here in person. Lucky us.
Live.
Live. Please
Chair,
proceed, sir.
Thank you, Chair. Good afternoon, Chair, Vice Chair, members of the committee. Craig Nakamoto, Executive Director for Hawaii Community Development Authority. We strongly support this bill. With the language in the bill that was adopted by the prior committee, it will give us, I think, the flexibility to engage the community, to do some rulemaking as to what sort of design and siting requirements should apply. It is not a one-size-fit-all for every landowner and every, it's very parcel specific. So I think it'll give us the flexibility to do some rulemaking to implement this law if passed. Thank you very much for the opportunity.
Sure. Thank you very much for testifying. Next, we have testimony in support from Chip Fletcher, University of Hawaii. Testimony in support from Hua'ina Hemaloto. Please proceed.
Aloha, Chair and members of the committee. My name is Hoina Hemaloto, and I am in support of SB 1417, which will promote and ensure sustainable development within the Kalailoa and Kapako communities, which are heavily being affected by climate change and the rises in sea level. So thank you again for this opportunity to submit testimony. Mahalo.
Mahalo. Next, we have testimony in support from Marianne Castro. Please proceed.
Good afternoon. Aloha, Chair, Vice Chair, and members of the committee. I am Marian Castro, graduate student at University of Hawaii for the School of Social Work. I stand by my written testimony in support of the bill 1417 relating to climate change for the development of site buildings in Kaka'ako and the Kalaeloa district. Thank you for the opportunity to testify.
Thank you very much. Next, testimony in support from B.A. McClintock. Testimony in opposition from Andrew Crossland. Testimony in support from Cards Pintor, Richard Schofield, and Will Curran. Is there anyone else here wishing to testify on Senate Bill 1417? If not, questions, members? I have one question for HCDA, Mr. Nakamoto. You've got two other community development districts, right? Heia and Pulehunui?
Correct.
Are they in the coastal area as well?
Pulehunui is not, I don't think, subject to inundation.
Would they be affected by impacts of climate change, sea level rise? And, I mean, should you consider the impacts of climate change, sea level rise, and climate resilient development in the design and siting of buildings in those other two areas too?
We don't think that they would be similarly affected. For the Heia district, it's largely preservation and ag. So I think there's the surface area over there would not be subject to that kind of.
Okay. And Pulehunui?
Pulehunui, we don't believe it would be subject to that kind of inundation.
Okay, so out of the four community development districts that you have under your responsibility, the two that are potentially affected as described in this measure are the two that are actually identified in here, Kaka'ako and Kalailoa.
That's correct, Chair.
Okay,
Thank
just
you.
making sure. Thanks
Thank
so
you.
much, appreciate it. Any other questions, members? Representative Ganadin.
So,
Sorry.
I'm surprised to not see testimony here from the Office of Foreign Affairs. Will this bill affect current plans to prospectively build in Kaka'ako?
I don't believe so. I think that's the reason why we were trying to keep the language in the bill, the implementing language, a little bit broader so that we can meet with the community stakeholders in the rulemaking process, representatives, so that we can understand sort of, what based on parcel-specific information, what kind of requirements or design requirements would apply. In other words, design requirements for larger parcels may not fit for smaller parcels.
If you think that those design requirements are going to be affected by sea level rise and climate change, are you going to ask the Office of Hawaiian Affairs to resubmit environmental impact statements?
I think what we're going to do is just we'll reach out to the Office of Hawaiian Affairs as a major landowner in Kaka'ako-Makai and ask for their input.
Okay, thank you.
Thank you. Any other questions, members? If not, thanks very much. We'll move on. Senate Bill 775 relating to hunting guides. This measure requires hunting guides who take their clients to hunt on private lands to first obtain written permission from the owner of the private land or occupier or holder, where appropriate, and requires these hunting guides to provide copies of the written permission obtained to hunt on private lands as part of their annual report to the Department of Land and Natural Resources. First up, we have testimony and support from the Department of Land and Natural Resources. Welcome. Floor is yours. Please proceed.
Aloha, guys. Yeah, we stand in support of our written testimony and available for questions.
And why do you think this is a good bill?
The way the bill, the rules that are already in place, we have trespassing laws already in our revised statutes, and we also have rules in our administrative rules that preclude trespassing. So why this wouldn't be bad on the department is because we already collect a report from all of our hunters or hunting guides, so having them submit a written permission slip from a landowner wouldn't be too much of a burden to us. I do feel, however, that it could curtail hunting a little bit just because private landowners could be living somewhere else or may be reluctant to sign a written permission slip. But overall, I feel that most landowners would be okay with this, and we can archive this information with the department.
Okay. Thank you very much. Next, we have testimony and support from the Hawaii Cattlemen's Council and testimony and support from Kanani Kupuniai. Anyone else here wishing to testify on Senate Bill 775? If not, questions, members? Quick question for DLNR. So currently, anyone who wants to hunt on private land needs to get permission from that private landowner, is that correct?
Correct.
And so right now, it just is not necessarily in writing.
Yes, it's a verbal.
Okay, so this changes things only in that they would get it in writing.
Correct.
And that they would need to provide it to you.
Yeah, with their report 30 days after they submit, or 30 days after they do the hunting operation, they need to submit us a report. And in this bill, it's basically asking them to provide a permission slip with that.
Okay. Okay, thank you.
Yep.
Any other questions? If not, we'll move on to the next measure. Senate Bill 735 relating to the disposition of water rights. This bill establishes that the public auction requirement for the disposition of water rights shall not be required for a lease of water for commercial kalo cultivation. First up, we have testimony with comments from the Department of Hawaiian Homelands.
Aloha, Chair Tarnas.
Aloha. Pleasure
Vice
to see
Chair
you, sir.
Takayama. Jonathan Lee KK Shore. I'm a consultant to the Department of Hawaiian Homelands on water policy issues. I'm here with Oriana Leao, who's normally before you. Just to summarize our testimony briefly, we worked with DLNR to modify the original bill in Senate Draft 1 out of a concern that the bill as originally drafted would negatively affect both DHHL's rights to revenue from water leases, as well as our ability to secure reservations of water, which is triggered under 17158G when a water license request or a lease request is issued. We were fine with that language. We also understand from the written testimony that's been submitted by other parties that there's proposed alternate language. We would also believe that that alternate language would protect the department's interest. Happy to answer any questions.
Just so I'm clear, in your testimony you say that we're also aware of a draft which would instead amend the end of Section H of HRS 171-58 to add the language, quote, including commercial kalo cultivation conducted in a manner consistent with traditional and customary Native Hawaiian practices and on traditional Kalo lands, period. And so you believe that alternate language would also not harm DHHL and beneficiaries' rights, as it is a narrow clarification of the current exemption.
Thank you very much, Chair. That is correct.
Okay, just want to make sure, because there are people who are listening that haven't read it, so I want to make sure they understand.
Thank you very much.
Thank you, Jonathan. Appreciate that. Next, we have testimony with comments from the Office of Hawaiian Affairs. Next, we have testimony with comments from Earth Justice, Isaac Moriwaki.
Aloha Chair, Vice Chair, members of the committee. Earth Justice stands on its comments and recommended amendments, which I believe are shared with other testimony submitted for this bill. We're available for questions as well. Mahalo.
Could you just read for us, you read it instead of me, what amendment you want to make in this? So just that one paragraph would be great.
Right. It's identical to the language that you just read in conversation with Dr. Scheuer, specifically modifying or amending the term commercial kalo cultivation with additional language, quote, conducted in a manner consistent with traditional and customary Native Hawaiian practices and on traditional kalo lands. I would just note that it's maybe not totally clear from the text of our testimony whether we're talking about the current bill draft that is adding a new subsection I, or modifying the original bill language that just added to the existing subsection H. And I just wanted to clarify, as far as Earth Justice's position, we're fine with modifying the existing subsection H with the language that I just read out.
Okay, thank you.
Thank you.
Next, we have testimony in support from Kelsey Amos. Testimony in support from Kevin Chang. Testimony in support from Hawaii Farmers Union United. Testimony with comments from the Council for Native Hawaiian Advancement. Testimony with comments from Kapua Sprout. Testimony with support from Julia Kaho'one, Regina Gregory, Will Curran, and Kanani Higby. Is there anyone else here wishing to testify in Senate Bill 735? If not, questions, members? Let me just check something here. Okay, members, I think you've got all the testimony before you, so if there's no questions, we'll move on. Thank you to the testifiers. Next, we have Senate Bill 316 relating to dogs. This measure establishes additional penalties for dog owners whose dog injures or destroys property of another while on private property zoned for agricultural use without consent of the owner of that property. On this measure, we have testimony and support from the Hawaii Cattlemen's Council, Nicole Galase, and testimony and support from Kanani Kapuniai. Is there anyone else here wishing to testify in Senate Bill 316? If not, questions, members? Okay, seeing none, we'll move on. Senate Bill 1268 relating to agricultural lands. This measure makes technical changes to the statutory definitions of agricultural enterprise lands and non-agricultural park lands for clarification and consistency purposes. First up, we have testimony in support from the Hawaii Department of Agriculture. Director, why don't you come on up so everyone can hear you and see you in TV land. Thanks for being here, Director.
Oh, yeah, thank you. I'm sorry. Good afternoon, Chair, Vice Chair, members of the committee. Sharon Hurd, Department of Agriculture. The department stands in strong support of this bill because it makes technical changes to two parts of the statute that brings them into consistency.
Thank you very
Thank
much.
you.
Next, we have testimony in support from the Hawaii Farm Bureau. Is there anyone else here wishing to testify in Senate Bill 1268? If not, questions, members? All right, if seeing none, we'll move on. Thank you very much to the testifiers. Next, Senate Bill 655 relating to hemp. This measure gives authority to the Department of Agriculture to align state hemp production administrative rules with federal exemptions for fiber, fuel, and seed grain hemp crops. First up, we have testimony and support from the Hawaii Department of Agriculture.
Thank you again. Good afternoon, Chair, Vice Chair, members of the committee. Sharon Hurd, Department of Agriculture. The department supports the hemp industry, and we stand in support of this bill as well, with the comment that we would like to delete the language on page 7, lines 7 to 11 of the bill that pertains to nuisance issues. We do not believe that belongs in this bill. Thank you.
Next, we have testimony and support from Hawaii Hemp Farmers Association. Gail Baber.
Yeah, aloha. Good afternoon, Chair, Vice Chair, and committee members. Thank you for hearing this bill and your support of farmers this session. The Hawaii Hemp Farmers Association is in strong support of this bill, stands on our comments. And I just want to explain real quickly, the value of this bill is allowing Hawaii hemp farmers to remain competitive. We're expecting U.S. Congress to amend existing hemp cultivation rules at the federal level, which will then impact every state, to allow exemptions for food, fiber, and fuel, basically make it easier to farm those sectors, because those sectors have been clamped down on. And those sectors are especially important for Hawaii, given our need for greater sustainability. So what this will do will allow the Department of Agriculture, will give them the authority to immediately align our hemp cultivation rules with federal, with the new federal rules that are expected to come out very soon. Instead of having to wait another legislative session or two and for rulemaking, this will again allow Hawaii hemp farmers to remain competitive. And just importantly to note that the fastest growing hemp sector in the state right now actually has to do with building supply and hempcrete. There are a number of projects on almost all the islands, and this bill would positively move those projects forward. And a number of those projects revolve around affordable housing, because hemp provides a wonderful alternative for building materials. So thank you.
Thank you very much, Ms. Baber. Always good to see you.
Aloha.
Next, we have testimony and support from Robert Bentz of Hawaii Sustainable Farms. Please proceed.
Hello, Chair Tarnas and members of the JHA committee. My name is Robert Bentz. I'm testifying in support and offering an amendment that we talked about earlier for Hawaii Sustainable Farms. I had a birth defect that led to me having a stroke and brain surgery in my 30s. I had to learn how to walk and talk from scratch. And in 2013, when the hemp first became federally legal, I was at Stanford at my hotel room testifying in support. Back then, Scott Enright was chair. He was very supportive of hemp. Unfortunately, during Governor Ige, the hemp industry has been horribly treated. And the last bill last year, at the last minute, it was changed. I have heard that the HB 1359 might also be torpedoed. The hemp program is supposed to be under the USDA AMS. I'm a licensed USDA AMS grower. They said that all hemp growing is under their regulatory jurisdiction. I asked them if there's any buffer zones. They said there's no buffer zones. I told them I read a law that there's buffer zones on the growth of hemp, and they said that they have regulatory jurisdiction. I followed through with calling a very well-respected law firm, Clark Hill, Robert Hoban. He also affirmed that this is a supremacy clause and my right to grow on my property. So I have a amendment that would help this, not only for the future, specifically the fiber. With 4 days ago, the Industrial Hemp Act, there's going to be a lot of different changes. So on that last sentence to section 1, I recommend keeping the most of the wording here, and I'll just point out the changes. It says, according to the purpose of this act is to authorize the Department of Agriculture to amend its rules to align with, and then this is the only small changes. It says the current USDA AMS rules as, and then period, as well as any is already there, and then adding future rules including, and comma, and then the rest is the same.
Thank you.
Exemptions, hemp fiber, because there's so many different rules. The current wording could kind of say that it's all this, but the growth of hemp is supposed to be completely under USDA jurisdiction. The processing of hemp, on the other hand,
If you could summarize, sir, that'd be great.
in summary, the processing of hemp is the Department of Health jurisdiction. So anything beyond raw agricultural commodity would be under state control. I really appreciate your bill on the Seeds of Wellbeing podcast. It helps farmers. There's a story about Cambodia. The government gave a disabled farmer a cow, and I'm not asking for the government to give me a cow. I'm just asking for the government to let me grow the cow that I already have on the land I already own. Mahalo, and cow is the hemp in this case.
Got it.
I appreciate it.
Thank you very much, sir. Appreciate your testimony. Next, we have testimony in support from the Hawaii Farm Bureau, testimony in support from Hawaii Farmers Union United, testimony in support from Ma'alahi Farm, and testimony in support from the Hawaii Farmers Union United Haleakala chapter. And testimony in support from numerous individuals, looks like about 20-plus individuals. Is there anyone here wishing to testify on Senate Bill 655 or on Zoom? If not, questions, members? I have one question for the Department of Agriculture. Chair Hurd. Mr. Bentz was saying that he thought that there might need to be amendments here just to make sure that the department could continually update your rules so that they are consistent with any federal rules that may be done in the future. But the way that I read this is that you're going to need to adopt rules, or you're authorized, or you shall adopt rules to effectuate the purpose of this part, and the rules to align with federal exemptions. And so you don't need language to update it every time there's a federal rule update. You'll know that you need to update your own ruals as well to be consistent.
May I consult with the administrator of the Quality
sure.
Assurance Division?
Sure. Do you want to come up and answer that? Question is, do I need to put language in here that says that you're going to need to amend your rules to align with the current rules as well as any future rules?
Leo Baldo, Department of Agriculture. Thank you for that question, Chair Tarnas. So right now we just have this statute. The rules, we don't really have any rules in place now, but we are in the process of adopting a permanent rule per the statute 141-4243. So the question on adopting federal rules, we are in support of that, for the 2023 Farm Bill. So right now, the fuel, fiber and seed grain, they are not exempted on the 2018 Farm Bill. So once it's exempted, we're gonna align our rules. Basically, we're not even implementing that, or we're not even regulating that in our previous rules. So it's, I think, something that the department can do. Regarding future amendments, we probably gonna be able to do that depending on what's going to be upcoming in the 2023. We don't know that yet.
Right, but I guess my question is, if we pass this language as is, will the department have the, will you be able to continually update your rules so that as the federal government updates their rules, you will follow suit and update the state rules?
Just for clarification, adopting rules, it's not a short term. It
I understand.
takes a year, sometimes 2 years or longer, depending on input from the industry. So if there are federal changes and we keep adopting our rules, I think that would be a big challenge for the department. I'm not saying we can do it. We may be able to do it, but it may take some time.
Okay, thank you.
Sure.
Yep, okay. Any other questions? If not, we'll move on. Next, Senate Bill 731 relating to Hawaiian Independence Day. This measure designates November 28th of each year as La Kuokoa, Hawaiian Independence Day, to celebrate the historical recognition of the independence of the Kingdom of Hawaii. On this measure, we have testimony in support from the Department of Accounting and General Services. Welcome, Director.
Thank you, Chair, Vice Chair, members of the committee. Representing Comptroller Regan, I am Dr. Adam Jansen. I have the privilege of serving as State Archivist and Administrator of the Public Archives. DAG stands on its testimony in strong support of this bill. We think it is very worth noting that La Kuokoa is one of the most significant historical events that have occurred in Hawaii. Without the signing of the Anglo-French Proclamation, the Hawaii that we know and love probably would not exist, because that halted the expansionist imperialist powers of the day of carving up the Hawaiian Islands as they did so often in the South Pacific and Africa. And unless we think that this recognition is a kingdom-only issue, it is worth pointing out that the state of Hawaii is the only government of Hawaii that has not yet recognized the historic significance of La Kuokoa. The Kingdom of Hawaii, the Republic of Hawaii, and the Territory of Hawaii all had this day on their official calendars. So we're hoping that this committee will help move this along and correct that and make sure that the state also helps recognize the significance of this event. I welcome any questions or comments you may have. Thank you.
Thank you, Dr. Jensen. Next, we have testimony and support from the Office of Hawaiian Affairs and testimony in opposition from Kenneth Conklin, and testimony in support from Angelina Wu. Welcome. The floor is yours. Please proceed.
Thank you. Aloha, o Angelina Wu, ko'i noa, he umi kuma uno o o makahiki. Hello everyone, my name is Angelina Wu. I am 16, a proud Native Hawaiian, and testifying in support of Senate Bill 731. What makes this bill unique is that it doesn't talk about buildings or budgets. It's about the mana or spirit of Hawaii's people over centuries. La Kuokoa was established in 1843 when England and France recognized the Kingdom of Hawaii as a sovereign nation. It marks the day the Hawaiians were heard. People would chant in the streets and celebrate with pride, but we only lost this because of an illegal overthrow. We were forced to forget our practices, language, and mana. But times have changed. We are in a sort of Hawaiian renaissance, and around this date, Native Hawaiians promote cultural issues and find mana within each other. Currently, during La Kuokoa, Kamehameha students march with pride, waving the Hawaiian flag and singing Hawaii Pono'i. Hilo's Boys and Girls Club hosted an educational conference, and news channels speak about its importance. Recognizing La Kuokoa would inspire youths like me, give peace to our kupuna, and take a vital step toward our Native Hawaiians and creating unity within our aloha as a state without any monetary cost. It is something so simple, so filled with mana. Mahalo nui e ola na hui e ola ka Hawaii.
Mahalo. Next, we have testimony and support from Julia Estegoi Kaho'one, testimony and support from Will Karen, testimony and support from Malachi Destin and Leimomi Khan. Is there anyone else here wishing to testify on Senate Bill 731? If not, questions, members? Representative Ganadin, please proceed.
Hey, good afternoon, Doctor.
Thank you.
Yeah, thank you for your service. In your testimony, you discussed ongoing legacies of colonialism and imperialism. some people consider that legacy to be in place in current American holidays, including Thanksgiving. Is it in statute that we have a holiday every month here in the state of Hawaii?
I am not able to answer that legally. I don't know of any statutes that require one holiday every month.
But we have one holiday every month.
There are a lot of holidays, yes.
Okay. Does DAG support the replacement of Thanksgiving with this holiday?
I am not in position to state for the comptroller whether or not we support that. But I do think it's worth noting that at this point, we are not replacing any holiday. This is not a day off. This is a day of recognition. And from our perspective, anytime we can discuss history openly and supported by the state is a good thing, particularly when we've already digitized all of the records of La Kuokoa and La Hoihoi'ea to be used to educate the populace and the visitors.
Would it be very difficult for the state to make this a day off like is in other celebrated holidays?
My understanding is quite a bit, because there is a huge financial implication to giving another day off or replacing an existing holiday.
So there's limitations to what we can really celebrate here. Can in the future, would DAGs or the state be interested in replacing what some people consider an imperialist holiday with this holiday?
I can confer with the comptroller and see where his stance is on that.
Thank you.
Thank you.
Thank you. Any other questions? If not, thank you very much. Thank you, Dr. Jensen. Next, we have Senate Bill 944 relating to the Uniform Parentage Act. This measure requires the Department of the Attorney General to convene a task force to recommend amendments to update existing parentage laws that reflect cis-heteronormative concepts of families, parenthood, and parental rights. The measure requires an interim report to the legislature 20 days prior to the regular session of 2024 and a final report 40 days prior to the regular session of 2025. First up, we have testimony with comments from the judiciary, Judge Viola. Next, testimony with comments from the Department of Human Services, Kathy Betts, Director. Next, testimony with comments from Michael Goliot. Please proceed.
Yes. Hello, Chair. It's Michael Goloyu Jr. with the Chair of the Stonewall Caucus of the Democratic Party of Hawaii. We chose comments because we didn't have a choice of annoyed or disgusted. The reason I say this is because this bill originally was supposed to address the needs of the LGBTQIA plus community, as you just stated in its purpose. At the last hearing, we raised concerns about expanding the scope of this task force for fear that our community would be erased. Unfortunately, our fears came to pass when, if you look at everybody who's listed on this new task force, there's no guarantee there would be any representation from the LGBTQIA community on this task force. It is quite clear that this now task force is to address the concerns raised by Laurel and other testifiers trying to turn birth certificates into a DNA tracker. If that's what this committee wants to do, that's fine by us. We still have hope that we can get HB 384 fixed to address the needs of the LGBTQI plus community when it comes to birth certificates and parentage. But if you do continue down this path, as it's been done, that eradicated our representation on this task force and make it a DNA tracker, that you do look at expanding this task force for other people, as we noted in our testimony, that there are other groups that would definitely want to be included in this. Sperm and egg donors that want to remain anonymous. A rape survivor that got pregnant from a rape, or a rape survivor advocate. Domestic abuse survivor, and a closed adoption advocates. Like we said, unfortunately our communities used to being erased and our bills being hijacked. This is just another thing, because when at the last committee they said this task force is for everybody, a chill went down my spine, because I knew what that meant, is that we were going to be ignored yet again. And unfortunately, it came to pass. So, like I said, if you want to go down the path as what the previous chair has done, that's fine by us. Just, you need to expand it to include those other people that definitely need to be part of this conversation with this task force. Because there are some grave concerns by making a birth certificate a DNA tracker. So on that note, I will leave you with that. Mahalo.
Thank you.
And I'm available for questions.
Thank you, Mr. Goloyu. Next, we have testimony and support from Jay Takane. Welcome. Please proceed. You can. Oh, actually, just if you could give it to.
You gotta go over there.
Oh, great. Thank you. And you could leave that there, and then we can testify there. Perfect. Aloha.
Aloha. Thank you, Chair Tarnas, Vice Chair Takayama, and members. My name is Jan Takani. I'm an adoptee. It's really interesting coming on the heels of the last testimony, but I am in support of a task force. My concern, much like his, is that some things in the task force will not be addressed, and so I really am here to advocate that, much like he is, to have a seat at the table. In front of you, I'm an adoptee. So in front of you, on one side, my right side is my biological family. On the other side is my adoptive family. Also in front of you are my 2 birth certificates. One is my original, and the other is my amended. If you look at both, you won't see any difference between the 2. You won't know. I really am lucky that I have adoptive parents that were very honest with me and gave me as much information that they knew truthfully about myself. And they really did put a lot of effort into helping me find my birth family. But the reality is, I don't expect this bill to be a DNA tracker. I do expect the child to remain with its own DNA and its own genetic background. Because somewhere down the line, whether it's for LGBTQ parents or, parents who are not LGBTQ, that child is going to have some sort of medical, some sort of genetic thing that the parent sees and won't really know what to do about it because it's not theirs biologically. And so I feel as long as you can do that, if you can keep the child with their information, their truthful information, that will be for the good of the community, the good of the child, the good of the parents involved, whoever parents them. So please, I'm just asking for the children's sake, a seat at the table. Thank you.
Thank you very much. I appreciate you sharing with us your personal story. Next, we have testimony and support from Kat McGlone. Please proceed.
Aloha. I am parked. I'm in my car, but I'm parked in a lot. Thank you very much for the opportunity to testify. I wanted to underscore what Jan just said, and I'm in support of the task force because it's a very complex issue that requires deep consideration and discussion. And everyone who would be affected should be at the table to have input. And this parentage bill will likely affect a lot of children who were created through assisted reproduction. And so it's important that they have adults that had that experience be at the table. I was raised in a closed adoption, not knowing anything about my family, my ethnic background, my medical history, or any of that. So I have that lived experience. And I think it's really hard for people who didn't have that experience to understand what that might be like. You always knew you looked like so-and-so, or you smiled like such and such, or you were interested in something or another that someone else in your family did, plus being able to have some notion of your medical history. So it's, and with the adoption experience of not knowing genetic heritage is very similar to those donor conceived who also don't know anything about at least half of their heritage. There are other unique issues, and which is why I think what's missing in the task force is to be sure that there's representatives from people who know about donor conception issues that have that lived experience. Because basically we're trying to, oops, what happened?
Oh, you're still there, go ahead.
Oh, you can still see me? Okay, my screen just went out. I don't know. Oh, sorry. What was I going to say?
Well, you can go ahead and summarize. That'd be great.
Okay. Yeah. So one of the main issues is transparency for the child and family to know. And while I'm a strong advocate for the child, knowing that the potential harms from not knowing, this really is in the benefit of the parents as well. They may not know it. Prospective parents of adopted or donor conceived children don't necessarily recognize that as that child grows or becomes an adult, they will have some issues of wanting to know. So actually it becomes everybody's concern and wanting the well-being for the child. And as far as like the issue about finding out that your parent was a rapist or whatever, I personally in my adoption support work, I know someone who found out after a long search that she was a product of incest. And I know of another person who found out that her mother was in a, mental hospital for chronically mentally ill. It's like knowing the truth is really important and freeing, having a history, whatever that is. And that, we have to deal with whatever our circumstances are. We all, we aren't all, have prince and princesses as our idyllic fairy tale families. But the truth and transparency is really important. And it's also important for like establishing Hawaiian eligibility rights for various like Kamehameha schools of being able to have access. So anyway, I stand by my testimony and thank you so much for the opportunity to testify.
Thank you very much for testifying. Next, we have testimony in opposition from Andrew Crossland, testimony in support from Laurel Johnston, Doreen Akamine, and testimony in opposition from Dara Yatsushiro. Is there anyone else wishing to testify on Senate Bill 944? If not, questions, members? Judiciary is not here. No. Okay, no questions. We'll move on. Next measure is Senate Bill 586 relating to transportation. This measure specifies that a certificate of inspection shall be issued if a vehicle is not equipped with a noisy muffler or exhaust system, and requires rules regarding safety check inspections to ensure that a motorcycle, moped, or motor vehicle is not equipped with a noisy muffler or exhaust system, and makes violating the noisy muffler laws a petty misdemeanor. Let's see, on this measure we have testimony in support from Tommy Penrose, testimony in support from Don Ballerin, B.A. McClintock, Becky Fonts, Richard Schofield, testimony in opposition from Clarence Regalado and GAV. Testimony in opposition from Ryan Willis and Kanoe Willis. Is there anyone else here wishing to testify on this measure? If not, questions, members? I wish we had no one to ask questions. I wish we had.
A gallery?
Yeah, I wish we had testimony from some other folks.
Can we just grab from the gallery? Do the public defenders want to weigh in on this?
They chose not to testify. We didn't hear from the public defenders or the prosecuting attorneys or the police.
All right.
All right. Noticeably absent. Yes.
Whatever. Fine.
Okay.
Right to remain silent.
Okay, moving on. We have Senate Bill 410 relating to expungement. This measure requires the judiciary and examiner of drivers to no longer include dismissed traffic citations on a person's record, including the traffic abstract and the judiciary's publicly accessible electronic databases. Requires the court to automatically seal or remove from the judiciary's publicly accessible database any information relevant to the arrest or case of a person for whom an expungement order listing the court case number has been entered and transmitted to the court. On this measure, we have testimony with comments from the judiciary. Next, testimony in support from the Office of the Public Defender. Welcome. The floor is yours. Please proceed.
Thank you. Good afternoon, Chair Tarnas, Vice Chair Takayama, members of the committee. My name is Lee Hayakawa. I am the Chief Deputy of the Office of the Public Defender. The Office of the Public Defender strongly supports SB 410 SD1 HD1. SB 410 streamlines the expungement process for individuals with expungement orders, requiring that the judiciary to automatically remove or seal the record from the judiciary's publicly accessible database without requiring these individuals to file a motion before the circuit court. This obviates the need for individuals who have an expungement order to seek the help and advice of a lawyer and makes the process an automatic one. Ultimately, this bill removes hurdles and increases accessibility to the legal system by everyday citizens of Hawaii. Chief Justice Rechtenwald, in his State of the Judiciary remarks delivered on January 25th, 2023, identified improving access to justice as a priority for the judiciary in 2023. The Office of the Public Defenders believes that SB 410 is consistent with these priorities, and we strongly support this bill. Thank you for the opportunity to testify.
Thank you very much. Next, we have testimony with comments from the Department of Prosecuting Attorney, Mr. Tom.
Chair, Vice Chair, members of the committee, Deputy Prosecuting Attorney Mark Tom for the department. I have no clue where everybody was on that last bill, but we're here for Senate Bill 410. So, department it provides comments with suggested amendments. Currently, speaking with the stakeholders, it appears that our access, at least our department's access to expunged or dismissed pursuant to this bill will not be affected. However, I can't speak for all law enforcement agencies. As well as if there's some unintended consequences that could happen, although we do not, it appears, utilize public access. So we provided some language in our testimony that we could possibly add to Section 1 to indicate that it's not to limit law enforcement agencies that need this kind of access to kind of get a clear and overall picture of an individual's traffic abstract, traffic record. So if that could be put into Section 1 to provide that clarification, the department would be very grateful. Thank you.
Thank you very much. Next, we have testimony and support from Kat Brady, Community Alliance on Prisons. Welcome. Please proceed.
Thank you. Aloha, Chair and members of the committee. We're in support of this measure. You know, right now the expungement process is really cumbersome and people have to go to court for it. So we just think there's so many things that could happen that are better. So expungement is really an investment in people so that they can get on with their lives. And it erases their past to show who they are now. And we really believe expungement leads to more and better jobs, better educational opportunities, it removes the stigma, housing, all sorts of wonderful things that everybody else in the community enjoys. In California, Governor Newsom signed a bill, and it takes effect July 1st. And in that bill, he talks about excluding certain people for violent offenses, but we're talking about traffic offenses here. These individuals would still have to, if the law stays as it is, they would still have to go to court, get an attorney. It's crazy. California is one of 6 states where ex-felons actually have ways to seal their records, and we think we need to get people, and I like what the public defender said about the access to justice. And I think that's really, really important. And it's about time that Hawaii streamlined the process. Thank you.
Thank you very much. Next, we have testimony in support from Carrie Ann Shirota, ACLU of Hawaii. Please proceed.
Aloha, Chair Tarnas, Vice Chair Committee members, Carrie Ann Shirota on behalf of the ACLU of Hawaii. We strongly support this measure. We believe that it is an incremental and important step towards a larger movement called Clean Slate, which is the automated system of expunging records from the past so that people can move forward in their lives. As we've highlighted in our testimony, when a person has a record, there are literally thousands of barriers that they may face as a consequence, sometimes years and even decades after the incident has occurred. The use of technology has been utilized in over 20 states, and there's an organization called Code for America that they, I'm sure, would be more than eager to work with our Hawaii judiciary into using technology to assist in this process. It's estimated, based upon Code for America, the scope of the problem that in Hawaii, over 500,000 people have arrest and/or court records. That is 1 or 2 or over 50% of people. Our current process is very cumbersome. It's outdated, it's using a paper, and this would be a win-win for judiciary staff as well as people who are unable to afford attorney navigating the very difficult process to expunge their records. And it's been highlighted by several speakers now that being eligible for expungement does not mean that you actually have access. And we see through our expungement clinics from people who have filed complaints with the Hawaii Civil Rights Commission, where they face discrimination in employment because of past records, including arrests, despite it being illegal under the law. And I think it's very important for us to recognize that we have decades of research highlighting racial disparities within our criminal legal system. On the continent, it disproportionately impacts African Americans, Latinos. Here at home, it disproportionately impacts Native Hawaiians. And so by passing this expungement process, it will help all people who are eligible for expungement, but particularly the Native Hawaiian community. And we ask that we continue to move forward with this trend towards clean slate and giving people meaningful opportunities to move forward in their lives, obtain jobs, provide for their families, and contribute to our community. Mahalo for the opportunity to testify and support.
Thank you very much. Next, we have testimony and support from the Hawaii Workers Center. Sergio Alcubilla. Welcome.
Thank you. Thank you, Chair Tarnas and Vice Chair Takayama and members of this committee. My name is Sergio Alcubilla. I am the Executive Director for the Hawaii Workers Center, and we stand in strong support of this bill. I understand there's 2 parts to this bill. I know the first part is on the dismissed traffic tickets. And just for trivia purposes, before coming here, I looked at our committee, and there are 15 traffic infractions from the members of the committee, ranging all the way from from being parked too close to a driveway. But I do have to commend there's 5 members that have no traffic infractions at all. But I just wanted to share that point because oh, thank you, Representative Gannon. I think you're one of them. but I just wanted to share the point of what happens when your traffic infraction, even though it's already been dismissed, is still on public record. But I'm here mostly for the second part, which is the expungement process. So this past weekend, we had an expungement process in Kahuku together with the Office of the Public Defender, and I want to thank them for all of their support. ACLU of Hawaii and the Lui Foundation. We had 40 people come and apply for help with their expungement. We had one lady that came, we had 2 actually that came all the way from Kauai. She came in with her suitcase, still pulling in, saying, "Oh, I just got off the plane and I'm here for the expungement process." Many of them are Kiai protectors. They were arrested for peaceful, nonviolent protest, but it's had such a big impact on their lives. I just wanted to share some of their comments as a result of their arrest. One person wrote, they're having a hard time to be hired. Another person wrote, I'm unable to get in as a member of the Bureau Council and get a job as a Manalomi practitioner in massage therapy. Another said, I've been vastly overlooked for several employment opportunities. Another believes that that record prevents them from visiting family members in jail. So there's real consequences to the expungement, to having an arrest record. And the expungement process, the way it is now, it is very cumbersome. It takes about 4 months to apply for the expungement, and then when you get that expungement, you have to then petition the court for your records to be sealed. So this would definitely eliminate that extra barrier. It would make it a lot easier. It would help provide access to justice for everyone, not just for those that can afford an attorney to do the expungement process for them. Chair, again, thank you very much for this time, and thank you very much for this opportunity to offer testimony and support. Thank you.
Thank you very much. Appreciate your research skills. Next, we have testimony and support from Diana Bethel. Is there anyone else here wishing to testify on Senate Bill 410? If not, questions, members? Representative Gannon.
Hawaii Workers Center. Sergio, come on. Thank you for your work.
Representative Gannon.
Yeah, hey, how you doing? If you look up my credit record, my credit score, I'm going to attempt to file a restraining order against you. So that said, thank you for your research into all of us. How does driving abstract affect insurance and a driver's ability to get and retain auto insurance to continue to drive?
You know, I may leave that for some of the other agencies involved regarding insurance, but I think one of the basic tenets of our justice system is that if you paid your time, especially if it's for a traffic ticket that's been dismissed and you've paid whatever fine it is, I don't know if the insurance companies look up your record that way, but that's all I can really speak on that part. I may have to leave it to the other agencies involved.
All right, thank you.
Thank you. Any other questions? If not, we'll move on.
One more.
Oh, go ahead, Representative Gannon.
Apologies. To the Office of the Prosecutor, Mr. Tom. When your office creates an initial bail report after arraignment, does your office normally look at traffic records?
I think that's created by a department within the judiciary. The bail report that's provided to our office is when we come up for custody court or arraignment. That's provided by think.
I think my question is more about, does the Office of the Prosecutor use these records to argue for continuing detainment for a charge?
Is there specific types of charges that we're looking? Are we talking about the expungement, or are we talking about the traffic infractions?
Traffic infractions, whatever the record might entail.
Routinely, if we're talking about, say, driving without license offenses, no motor vehicle insurance offenses, I don't believe a lot of the individuals are in custody, that they're being held, and we're determining bail. I think they're issued a citation, and no bail is applied, is on that case, so it shouldn't really apply. We're not arguing, at least with those traffic tickets. If it's a different type of a higher level, maybe a negligent homicide or some type of traffic offense like a hit and run where somebody's injured, we could look at those types of infractions. We can look at petty misdemeanors to indicate why somebody should be held in custody, or the judiciary will also look at those to determine if they should be released on supervised release, if they should be released pending trial.
I understand. So would the record also indicate whether or not someone was arrested but not convicted for a petty misdemeanor or a misdemeanor stemming from a traffic charge?
I think those would be through judiciary's gyms. You can look at the traffic minutes. So that's something that would be through public access. So an individual could look at, say, any of your traffic tickets that you had and kind of look at the minutes of what exactly happened if you were arrested, if you posted bail. So that would be within the purview of the judiciary's database.
So it's within the judiciary database, so you could use it to, again, argue for continued detainment for whatever charges comes up later.
Yes, we would have access, like anybody else that has public access. They would be able to observe, to research that and see if an individual was arrested or not.
If we pass this bill, will you still have access to those records, but the public won't?
That's the clarification that we're making sure, is that right now, it does not appear that this bill, and talking with stakeholders, will affect that access. However, ensuring that we're still able to access those databases to gain a full grasp of the picture of a person's driving history or criminal history is very key for law enforcement agencies.
I understand. Thank you.
Thank you.
Thank you very much. Any other questions? If not, thanks. We'll move on. Next measure, Senate Bill 921, relating to limitations of actions. This measure clarifies that no statute of repose shall affect a condominium association's right of action against a condominium developer sooner than 2 years after the period of developer control terminates. On this measure, we have testimony and support from the Hawaii Council of Association of Apartment Owners. Next, we have testimony in opposition from BIA Hawaii. Next, we have testimony in opposition from NIOP, which stands for, let me get this. It stands for the Commercial Real Estate Development Association. What does NIAP stand for?
NIAP is actually is just an acronym now. It doesn't really stand for
Oh, it doesn't stand for anything?
anything anymore.
Oh.
Apologies, Chair, on that.
Shoots. Okay, Evan Oye with NIAP.
Yeah, Evan Oye on behalf of NIAP Hawaii. Chair, I did want to apologize for our late testimony. We do stand in opposition to this measure, given our concerns that what this may have in terms of additional costs, particularly on affordable housing projects, which our state direly needs at this time. Those costs are associated with the increase in, exposure to liability, which in turn increases insurance premiums costs, and which ultimately may need to be passed down to the consumer or the home buyer at this time. So respectfully, we do want to note those concerns and ask, express our opposition to the measure at this time.
Okay, thank you very much.
Thank you.
Next, we have testimony and support from Richard Emery, Mark Hagedorn, and Larry McGuire. Is there anyone else wishing to testify on Senate Bill 921? If not, questions, members? Let's see. Mr. Oye, since you're here and I couldn't figure out what NIAP meant, I could ask you a question.
Yes, Chair.
I checked, and my understanding is this wouldn't really expose to developers an increased liability, except in the sense it's harder to find problems before the developer relinquishes control, but you'd still be responsible for the same things. It's just that after the developer control is relinquished, then perhaps the problems might be easier to find. So I think that was the rationale behind it, but it didn't seem, you'd still be responsible for it.
Correct, but I think it's just the lack of clarity regarding when, just for background, the statute of repose offers like a clear definitive date in which you can't continue to bring claims after. We would still be responsible prior to that date, but from an insurance standpoint, I do believe that there's a lack of certainty which could increase risk, and then they would have to take that into consideration when a developer goes in for its insurance to cover.
Okay, all right, thank you very much.
Thank you, Chair.
If there's no other questions, let's go on to the next measure. Next, unless you have a question. No, you're gonna pass it on. Okay, Senate Bill 1468 is the next measure relating to right of entry for professional surveyors. This measure authorizes professional land surveyors and any assistant under the direct supervision of the professional land surveyor to enter any private property to perform land surveying subject to certain provisions regarding objections, notice, and identification. And it shields the professional land surveyors and assistants from prosecution under criminal trespass laws when performing their duties. On this measure, we have first up testimony and support from the City and County of Honolulu Department of Design and Construction. Next, we have testimony with comments from Sheena Choi, Board of Professional Engineers, Architects, Surveyors, and Landscape Architects. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. My name is Sheena Choi, Executive Officer of the Board of Professional Engineers, Architects, Surveyors, and Landscape Architects. The board stands on its written testimony with comments, and just to briefly summarize, the board supports this bill's effort to establish a right of entry for professional land surveyors to conduct a survey that protects the real property interests of property owners, as well as the public interest in maintaining the integrity of a sound, uniform real property system. Thank you.
Thank you very much. Next, we have testimony and support from Lindsay Garcia, Hawaii Realtors. Welcome. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Lindsay Garcia from the Hawaii Association of Realtors. We support this version of the bill. We appreciate all of the hard work of the previous committees and support the amendments made. In particular, we support the clarification that the right of entry only applies to adjoining lands and not to any building, structure, residence, or vehicle on the property. We also support the provision that owners receive a written notice of at least 10 days before the proposed survey date. This ensures that property owners are given sufficient time to be informed of survey activities, particularly in cases where their owner may be away or where tenants occupy the property and must be informed by the owner as well. We are also in support of a property owner or tenant's ability to send a written notice of refusal of entry, as well as the ability to reschedule to a mutually agreeable date and time with the land surveyor. So we're in support of this measure. Thank you.
Thank you very much. Next, we have testimony and support from the Hawaii Land Surveyors Association, Meyer Cummins. Welcome, sir. The floor is yours. Please proceed.
Aloha, Chair, Vice Chair, Representative Souza. My name is Meyer Cummins. I represent the Hawaii Land Surveyors Association. HLSA stands in strong support of this bill for many of the reasons that Lindsay already said. A lot of work's gone into this. We've come a long way. I think we've struck a good balance between the interests of surveyors, property owners, and the state. So we'd like to see this bill move forward as is. Thank you very much.
Thank you very much. And we've received testimony and support from numerous individuals: Dawn Fukutomi, Leo Bell, Eric Kaneshiro, Joe Charles, Christina Villa, Louis Per, Victor Brasgado, Cliff Yim, and Kanani Kapuniai. Is there anyone else here wishing to testify in Senate Bill 1468? If not, questions, members? I have one question for Mr. Cummins. When I compare this bill to House Bill 1241, the one thing that is missing in this bill is a sentence that we had, which I want to read to you. If the landowner or occupier of the adjoining lands does not make a timely objection, the land surveyor and any assistant under the direct supervision of the land surveyor shall be authorized to enter the adjoining land pursuant to this section. So that was in the House bill.
Mm-hmm.
So if there is a non-response from the adjoining landowner, within the time given, that you would be authorized to
Correct.
enter.
It would be an implied consent.
Yes. That is not in the current bill.
Oh, I believe I thought I saw that. I'm sorry. I'd like to see that in the bill.
Okay, that was my question.
Yeah, gotcha.
If
yeah.
it's not in there, I think it would be
we would
useful.
like we would
you
like
agree?
to see that. Yes, absolutely.
Okay.
Yes.
Thank you.
Thank you.
Any other questions? If not, we'll move on. Thank you very much. Next, we have Senate Bill 1196 relating to boards and commissions. No one's testified on this. Is there anyone here wishing to testify on this? Okay, if not, we will move on. Thank you very much. Next, we have Senate Bill 415 relating to wages. This measure makes general contractors entering into or under contracts in the state for work on buildings, structures, or other private construction works liable for debt incurred by subcontractors for wages due to claimants, including interest owed for performance of labor in the contract between the general contractor and owner. That's a mouthful. On this measure, we have testimony and support from the Hawaii Department of Labor and Industrial Relations. Welcome. Please proceed.
Good afternoon, Chair Tarnas and Vice Chair Takayama and members of the committee. My name is Kristen Lee, and I'm representing the Department of Labor and Industrial Relations. The department stands on its testimony in support of the measure, as the proposal seeks to hold a general contractor liable for any unpaid wages and interests that a subcontractor at any tier owes to its employees for work performed under a private construction contract. The department will also be available for any questions. Thank you.
Thank you very much. Next, we have testimony in opposition from the Subcontractors Association of Hawaii. Next, testimony in support from Pacific Resource Partnership. Next, testimony with comments from the General Contractors Association of Hawaii. Mr. Sakuda, welcome. The floor is yours. Please proceed.
Good afternoon, Chair, Vice Chair, members of the committee. GCA stands on its written testimony providing comments and available for any questions.
Mr. Sakuda, could you give me a highlights why you think this is or what you think of this bill? You just say comments.
Yep, so this is a proposal that was brought to the general contractors by the proponents of this measure. We went back and forth, and in the spirit of compromise, we came up with this draft. So as long as this draft stays the way it's written, we do not have any concerns with it, as current law already has the ability for general contractors to be liable under the mechanics lien statutes.
Okay, thank you very much. Next, we have testimony and support from the Hawaii Regional Council of Carpenters. Mr. Kinney, welcome. Floor is yours. Please proceed.
Thank you, Chair. We're in support of the measure. We've put in some testimony outlining to address some of the concerns that somebody has brought up. Some of the detractors of the bill have brought up. When you look at what their testimony basically boils down to, it's like they're saying that the record keeping requirements for contractors are onerous, and I did want to mention that if you look at chapter 387-6, and it lists all the things that an employer must furnish or keep records when it comes to an employer. It basically, when it comes to an employee, it basically says that an employer needs to keep track of who is an employee is, what they're paying them, and how much they're paying them. So when I hear about, oh, this is onerous and it requires record keeping, I don't understand how somebody, any businessman would have a problem keeping track of who their employees are and how much they're paying them. And then there's questions about like, oh, this somehow gets in the way of the payment of wages, or I mean the payments between general contractors and subcontractors. That is actually tied to the record keeping requirement. So if a subcontractor doesn't provide the records of their payments to the general contractor, then the general contractor has a right to withhold payment. But the question that I have is, for both contractors, large and small, why is it so onerous to have, I even believe the statute refers to handwritten or typed records of what they're paying their employees and how many hours. So what I have found though in the industry, unfortunately, and what this bill is trying to combat, is a lot of contractors have two sets of books. They have the set of books that they have to keep track of wages and withholdings, and then they have another set of books in which they keep track of the cash payments. And that is exactly what this bill is trying to combat. And general contractors using the veil of a subcontracting relationship to say, well, I didn't know that that person was getting paid cash, that was a sub, or that was the sub of a sub. I think that subs and subs of subs all should be keeping track of how much they're paying their employees, and if everybody can show those records when requested, under the statute, they're supposed to keep these records for over 6 years.
Okay.
This is well-settled law from 30 years ago. So again, in support of the measure, and then any questions about private right of action by labor management committees, as noted in my testimony, of the 7 jurisdictions that have passed this law, 2, California and New Jersey, have this. So we're not breaking any new ground. Thank you.
Great, thank you very much, Mr. Kinney. Next, we have testimony in opposition from BIA Hawaii. Testimony with comments from the Plumbing and Mechanical Contractors Association of Hawaii, and testimony in opposition from Natalie Iwasa. Is there anyone else here wishing to testify in Senate Bill 415? If not, yes, 415? Yes. Please come on up to the podium. Introduce yourself so everyone, all your fans out there can hear you.
Chris Delaney with Pacific Resource Partnership.
Oh, great.
I believe you probably called me earlier.
Called you, yes.
I just missed you, but anyway, I
Please
would like
testify.
to Yes, I would like to express our strong support for this measure. This is going to help to hold unscrupulous general contractors accountable for supporting and ignoring the unfair labor practices of their subs that they're well aware of. We've seen this abuse throughout the state of Hawaii, and I think this is a great bill to now finally make them accountable. And as Nat Kinney from the Hawaii Regional Council of Carpenters said, that they should have this kind of documentation at hand already because it's required by law. So I think this is a great bill and would appreciate your support. Thank you.
Thank you very much. You arrived just on time. Thanks, Mr. Delaney. Anyone else wishing to testify in this measure? If not, questions, members? Representative Ganadin.
Mr. Kinney from the Carpenters.
Yes, Representative.
Hey, we're on the clock. Can you briefly explain how contractors might, or laborers might receive payment through a mechanic's lien? Seems like a technical legal process. Is it?
No, I think that's addressing more like the subcontractors. So what some of the detractors of the bill are saying is that somehow, because of this bill, that general contractors wouldn't pay subcontractors. But the reality of it is that because of the mechanic's lien, if a subcontractor wanted to force payment from a general contractor, you have the mechanic's lien, which basically says like you can basically sue, hold the job on until they get paid. So that's like one of the mechanic's lien is probably the most powerful method of payment. So it kind of bewilders us when we're saying, oh, somehow the passage of this bill will hold up payments from generals to subs when subs have this like huge hammer in the form of a mechanics lien. Now you're talking about laborers, and that's different, like the actual workers on a project. Is that what you're talking about?
Yes.
So under this bill, that laborer can go to the Department of Labor and Industrial Relations, or it could approach a labor management committee and help get paid. But this is really the only way they could get paid, because what's been happening is general contractors hire bad subs pay cash or don't pay at all, and then the subcontractor employee shows up, goes, hey, I want to get paid, and everybody's like, sorry, what are you going to do? So this actually adds more tools to allow people to collect for unpaid wages.
Are there issues regarding like large statewide issues regarding like non-payment of laborers, or using I don't want to use an incorrect term, like unlicensed laborers to do this kind of subcontractor work throughout the state, and then paying them cash, or like paying them unfairly the way this happens with usually like sometimes migrant labor in the United States? Does that happen here?
Yeah, actually it happened in Waikiki maybe about 3 or 4 years ago at Miley Sky Court. And we're not talking about a small job. We're talking about a multi-million-dollar hotel renovation. And then right after we caught people in Waikiki, we caught another contractor doing 2 different multi-million-dollar hotel renovations in Kauai, and then another contractor in Maui. So it's just been happening so often that it's becoming, and then you show up on the job. So what happened at Miley Sky Court was our labor management cooperation fund, Pacific Resource Partnership, found out about this job, surveilled the job, found out that this contractor had brought in a bunch of migrant labor and wasn't paying them or paying them cash, and then turned that information over to the state and federal authorities. They came up, the state and feds, when they rated the job, came up with like a $1.2 or $1.3 million in damages. The general contractor walks away, goes, I didn't know that was happening on the job. The subcontractor goes bankrupt, and everybody was left without getting paid. Now, in this instance, if the law had been in place, what would have happened was we could have levied those fines. If the subcontractor couldn't pay, then the general contractor would have had to pay, and then the migrant labor would have gotten paid, and damages too. So thank you.
Thank you.
Thanks very much. Any other questions?
I have a question.
Yes, please, Representative Souza.
Just one last question.
Oh, you're back up.
Yeah, sorry, you again.
All right. That's why he's sitting next to the podium.
Yeah.
I just have a question as to, do you think that there could be really honest general subcontractor or general contractors who could perhaps be a victim to this because of shady subcontractors? I mean, I guess we're kind of looking at it the opposite way, right? That general contractors would, maybe intentionally hire dishonest subcontractors, but would there ever be a time where the general contractor would fall victim to this particular measure, or
So you're
negative
saying, like
or-
in an instance when a general contractor hires a subcontractor and then the subcontractor doesn't pay its employees, and so
yes,
what,
if they're
what-
following all the honest business practices and it's not, meant to be shady. I mean, because, in your testimony, you talk about how, it's not supposed to be a heavy burden on the general, but I'm sure there's times where it will be a heavy burden because of just dishonest subcontractors and not by any fault of the general contractor, correct?
Well, I can take a note from some of the other jurisdictions that have passed this law. California, New Jersey, New York, Illinois, Virginia, Nevada, District of Columbia, to name a few. What has happened is when you pass this law, general contractors, because they know they're on the hook for this, have a propensity to start hiring more reputable subs because now they're on the hook for it. So what has happened is actually the reverse. Because in some other jurisdictions, they complain about, oh, the bonding rates are going to go up because now the bonding companies are on the hook in case the sub fails. So that's normally what would happen. If a sub fails, the bonding company for the sub comes in and pays for it so that the general contractor can finish the job. What they're actually seeing is the reverse is actually happening. So because the general contractor knows that they're liable, they start choosing more reputable subs, and more business starts flowing to people that they know that can pay their workers and they know will finish on time and on budget. So it's actually the reverse is true. What we have a situation of now is it's the lowest common denominator. A general contractor will go with the cheapest person, and then when they fail, they'll just go after another cheap person. Whereas when you start rectifying the system, you start cracking down, what happens is more reputable contractors start getting more work because I'm a reputable subcontractor. I give a $1,000 or $100,000 bid. A non-reputable subcontractor shows up, gives a $50,000 bid. A general contractor's like, $50,000 could be the difference between me getting the job and not. So they go to the disreputable subcontractor and then have issues with payment of workers. Whereas when the general contractor's on the hook, it's like, well, wait a second. I know this guy's $100,000, but I know he can pay his guys, and I know he's going to do it on time and on budget. So it's actually the reverse is true from what we found.
Thank you so much.
Thank you.
Thank you. Any other questions, members? If not, we'll move on to the last measure on our agenda. Senate Bill 1057 relating to employment earnings. This measure requires certain job listings to include an hourly rate or salary range. Prohibits an employer from discriminating between employees because of any protected category established under state law by paying wages to employees in an establishment at a rate less than the rate at which the employer pays wages to other employees in the establishment for substantially similar work. On Senate Bill 1057, first up, we have testimony and support from the Hawaii Civil Rights Commission. Welcome. The floor is yours. Please proceed.
Thank you, Chair, Vice Chair, members of the committee. My name is Robin Wurtzel, speaking on behalf of the Commission. We stand on our testimony. I want to point out that this is, we're in strong support of this measure. It would really level the playing field and I think end paid disparities in a much greater way than previous legislation has done. It's a proven measure in other states. I realize that there's going to be a great deal of testimony in opposition to this measure, as we've seen in other committees, but a number of states have passed it. There doesn't seem to be any negative blowback from those states, and there is a great deal of positive. Other than that, I'm available for questions if people have any.
Thank you very much. Next, we have testimony and support from AAUW of Hawaii, Nancy Rusted. Please proceed.
Hi, thank you, Chair Tarnas, Vice Chair Takayama, and members of the committee. I am not Nancy Rusted. She provided testimony on behalf of AAUW in support, and unfortunately she couldn't be here, so she asked me to step in and provide some comments. One of the things she asked me to tell you was that advertising a job within a salary range actually benefits employers, because it attracts only those applicants that are willing to pay for work within that salary range. So if employers would not have to interview or screen the wide range of potential employees, employers should post a range that they're willing to negotiate within. So there's nothing that precludes them from including other benefits. These are all negotiable because we understand that salary, while it's an important element, is only one element of compensation. Small businesses are a concern because while they've always had difficulty competing with larger companies that can provide better benefits. So it's not unique to this bill. We understand that they have a problem. They continue to have the problem. So I want to point out that the federal government and its millions of employees do have salary transparency. They do have banding. The state of Hawaii has it. Honolulu County and most of all the counties of Hawaii also provide salary transparency. They have no difficulty in attracting and hiring employees. And applicants in the private sector should be allowed the same kind of transparency. Transparency alone will not close the gender pay gap, but it's a very important step in addressing some of the systemic problems that we see. So thank you very much for hearing my comments.
Thank you.
If you have any questions.
Thank you very much. That's Miss Amy Monk, AAUW
sorry.
of Hawaii. No, not you're.
I'm sorry.
You're famous.
Did
It's
I
okay.
not introduce myself?
It's okay. You just told me who you weren't at the beginning.
Okay.
But now I just want to make sure everyone knows who you are.
Thank you, Chair Tarnas.
You're most welcome, Amy. Next, we have testimony in opposition from the Chamber of Commerce of Hawaii. Next, we have testimony in support from the ACLU of Hawaii. Carrie Ann Shirota. Please proceed.
Aloha Chair, Vice Chair, committee members. Carrie Ann Shirota on behalf of the ACLU of Hawaii. We strongly support this measure. As has been echoed earlier, we have a constitutional amendment that prohibits discrimination on the basis of sex and other protected basis. We have other laws on the books, but yet we still have a practice of pay secrecy within our community. Flipping that, pay transparency will be a tool to actually effectuate pay equity in our community. Statistics are very clear that in the last year, Pew study came out and said in 2022, women earned an average of 82% of what men earn, according to the median hourly earnings of both full and part-time workers. Here in Hawaii, women are making 79%, even lower than that national average, which is already below what men are making. We want to highlight that this bill, we want to hone in on the gender disparities based upon salary, but it also impacts other protected bases. Historically, other marginalized and intersectional groups, including women of color, LGBTQ community members, women with disabilities, they're especially vulnerable to pay inequities. The current system of voluntarily disclosing pay transparency disadvantages, particularly women, who are often at a disadvantage in terms of negotiating their salary, particularly when women who negotiate have to reference past salaries, and when they're paid historically less, what happens is that we start compounding the problem. We build upon years of disparities, which further widens the pay gap. Contrary to concerns that have been raised in opposition to this measure, if you look at the history of civil rights, there's consistently been opposition to efforts to codify practices and tools to allow for transparency and pay equity, equal terms and conditions of employment. And there's studies that show that actually transparency helps employers by retaining talent and building more trusting relationships with employees. We strongly ask that people get paid substantially same wages for substantially similar work, and that you essentially bend and effectuate this law to the side of justice. We ask that you pass this measure and that we move forward based upon principle and pay equity, and that we give a new tool for not only employers, but also employees. Thank you for the opportunity to testify.
Thank you very much. Next, we have testimony in opposition from Retail Merchants of Hawaii, Tina Yamaki. Next, we have testimony in support from Nicole Wu, Hawaii State Democratic Women's Caucus. Testimony in opposition from Michael Iosua with the National Federation of Independent Business. Testimony in support from the Hawaii Appleseed Center for Law and Economic Justice. Testimony in opposition from the Society of Human Resource Management Hawaii. Testimony in opposition from the Maui Chamber of Commerce. Testimony in support from Jean Evans. Welcome. Please proceed.
Thank you, Chair, Vice Chair, committee members. My name is Jean Evans. I've been working in Hawaii, here on Oahu, for 40 years, and most places have been nonprofits, and I've been in executive director's positions. A few years back, not too long ago, 10, 15 years ago, I applied for an executive director position, which I did actually get, and I was real happy about that. But when I asked them what the salary range was, they said, oh, it's negotiable. And I said, can you give me a little more hint? And they go, well, no, it's really negotiable. And they came up with a number that sounded really good to me because it was a raise from what I'd made. And so I was happy, worked there 3 months, found out that my predecessor had made twice what I was making. And it really, really made me angry and it made me feel so stupid. And so I started looking around for another job. I've hired hundreds of people and done lots and lots of interviews over the years. And I've also interviewed probably hundreds of people who would never work for the salary that we could afford. And it just wasn't even thought of to post salaries. And so you waste their time, you waste our time. It was really pretty upsetting. I've heard that small businesses have a hard time coming up with a salary range to post. Everybody's got a budget. So you just look at your budget, you add a little bit above it, below it, that's your range. And ranges can be changed in economic conditions too. So you move the range. If there's a problem or if things get better, you move it up. You let everybody in the company know. And you post that. I've heard something about job performance isn't taken into consideration. Well, you don't really take consideration when you're hiring somebody on job performance because you don't really know. But you do after they work there for a while. If it's poor performance, you review them. Hey, you either terminate them, you put them on notice, you give them a warning, whatever. If they're doing a really good job, you give them a raise within that salary range. It's really, really easy to do. There are 7 other states that have this law. There are 21 that are pending right now. And it is, job candidates feel much more connected to the company. They feel like they're being treated fairly. And millennials, it's been shown that they really prefer transparency, and we're trying to hire millennials, so they want to cut through all of the red tape and know what's right and wrong there. And so it's a win-win situation. You save money by the employers, and so please support this bill. Thanks.
Thank you very much. Next, we have testimony and support from Kelly Chan. And next, testimony and support from Elizabeth Hansen, Roger Hansen, Carolyn Kunitake, Younghee Overly, Beth Anderson, Brianna Zoe, Sarah Rosenbach, Abby Simmons, Jarrett Pasquale, Janet Morse, Jody Shiroma, Will Curran, Lori Temple, and Pua Oyong White. Is there anyone else here wishing to testify in Senate Bill 1057? If not, questions, members? Seeing none, that's all the measures on our agenda. We have enough to go into. We're good to go for decision-making. Thanks, everyone, for being here. Let's go to the top of the agenda, Senate Bill 966. I think people are in agreement on this one. I'd like to keep the defective date and move it forward as is, no changes. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 966 HD1 passing as is. Chair and Vice Chair vote aye. Representative Ganadin. Aye. Representative Holt, excused. Representative Hashimoto. Aye. Representative Ichiyama. Aye. Representative Ilagan, excused. Representative Kong. Aye. Representative Mizuno. Aye. Representative Souza.
Aye.
Chair, your recommendation is approved.
Thank you very much. Next measure, Senate Bill 388. After reviewing all the testimony, I'm very concerned after reading the testimony from the Department of Health, from the Department of Environmental Management in the County of Hawaii, from the Solid Waste Management Division on Kauai, that we may be foreclosing their ability to site waste facilities. I recognize that siting of a waste facility still must make sure and ensure that there is no leakage into the aquifer and prevent any contamination of the groundwater, because they have to comply with the Clean Water Act and the Resource Conservation and Recovery Act and applicable Hawaii statutes and rules. And so I recognize the concern of the Board of Water Supply and your testimony, but I also note that in a previous effort in City and County of Honolulu to site the landfill, it failed in part due to concerns of siting a landfill over an aquifer. So I think your input, the Board of Water Supply input, is taken into consideration. But I am I would like to defer this measure because I think that it would cause a lot of difficulty for all of our counties in deciding how to manage our waste in a responsible way. And so that's my recommendation on that measure. Let's move forward on the next one, Senate Bill 1417. On this measure, I was cognizant of comments that was on second reading, that why are we focusing just on these two areas, Kaka'ako and Kalailoa? Is there some other agenda here? For members who weren't here, I asked the Hawaii Community Development Authority that of their 4 community development districts, right now we're only mentioning 2. I said, did Heia and Pulehunui Community Development District have similar issues? And they said, no, this is not something that they feel would be applicable to those other community development districts, but Kalailoa and Kaka'ako are the 2 that it would be applicable to. So with that in mind, I would like to move this forward because I think that it is reasonable that in these 2 areas, HCDA should consider the impacts of climate change, sea level rise, and climate resilient development in the design and siting of buildings in the Kaka'ako and Kalailoa Community Development District. So my recommendation is move it out as is. Comments or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1417, SD1, HD1 passing as is, noting the excused absence of Representatives Holt and Iligan for the remainder of the agenda. Any reservations or noes? Seeing none, Chair, your recommendation is adopted.
Thank you very much. On Senate Bill 775, on this measure, I'd like to recommend an amendment to pass so that we pass it out as a House Draft 2. On page 2, line 18 and 19, we would add some words so that it would read, this is getting written permission, quote, from the owner, occupier, holder, or duly appointed agent thereof of the land or premises. That way we're being consistent throughout this measure with that language. We'll keep the effective date and move it out as an HD2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 775, SD1, HD1 with further amendments. Any reservations or no? Seeing none, your recommendation is adopted.
Thank you very much. On the next measure, Senate Bill 735, I would like to recommend moving out a House Draft 2. We would retain the effective date, but I'd like to include the amendment from the Department of Hawaiian Homelands, which was echoed by Office of Hawaiian Affairs, Earth Justice, KUA, CNHA, Professor Sproat, which would be to add language on Section H of HRS 171-58, the language, quote, including commercial kalo cultivation conducted in a manner consistent with traditional and customary Native Hawaiian practices and on traditional kalo lands, end quote. That's my recommendation. Any questions or concerns, members? And I want to thank the Waterland Chair for prior concurrence. Any questions or concerns? If not, Vice Chair for the vote.
Voting on Senate Bill 735, SD1, HD1 with further amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. Moving on to the next measure, Senate Bill 316. I'd like to make technical amendments on this only and move it out as a House Draft 2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 316, HD1 with further amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. On Senate Bill 1268, I'm comfortable with this. Testifiers are comfortable with this. It's a technical housekeeping measure, so I'd like to change the effective date to be upon approval and move it out as a House Draft 2. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1268, SD1, HD1 with further amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. Next measure on relating to hemp. On this measure, I would like to add on page 2, line 19. So this is in section 1 of the bill, just to make it clear, because I wasn't sure if I was getting the message through to the Department of Agriculture. So it says, the purpose of this act is to authorize the Department of Agriculture to amend its rules to align with the U.S. Department of Agriculture rules, including any federal exemptions, et cetera. So that way, they know that as the U.S. Department of Agriculture develops rules, they're going to need to modify them to make sure they're consistent. I'd like to make some technical amendments, and then also make a change in here so that it is consistent throughout. On page 4, line 13, change the phrase, it's currently home or dwelling, and we should change it to be house, dwelling unit, residential apartment, or other residential structure. So it's consistent throughout. And I said also technical amendments for clarity, consistency, and style. We will keep the defective effective date. That's my recommendation. Members, questions or concerns? If not, Vice Chair for the vote.
Voting on Senate Bill 655 SD1 HD1 with further amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. Next measure, Senate Bill 731. I think this is timely, and it's about time that the state does this, so I'd like to recommend we move it out as is. Questions or concerns, members? Yes, Representative Ganadin.
Chair, I suggest that we consider having this as a day off and a state holiday. November 28th, every year should be a state holiday, day off, to celebrate the independence of the nation of Hawaii.
I noted. And I would urge you to work on that next session. But we won't have session that day, so I just want to make sure everyone knew, don't show up for session that day. So let's pass this out as is. Any other questions or concerns, members? This is a very important recognition. It's something that we need to acknowledge and celebrate and make sure that everyone knows about this because it's not often acknowledged. And thanks to Dr. Jensen, we can visit the archives and see some of these amazing artifacts and records from back then. If there's no more questions or concerns, Vice Chair for the vote, please.
Voting on Senate Bill 731 passing as is. Any reservations or noes? Your recommendation is adopted.
Thank you. Next bill, Senate Bill 944, relating to the Uniform Parentage Act. I would like to recommend we change the effective date to June 30th, 3000. Make a small change on page 2, line 9 and 10, just to make it clear that the report is, quote, of its findings and recommendations, including any proposed legislation, to the legislature. And I would like to move this to conference committee. And I will note for the members that House Bill 384, which we've moved out, it's now in the Senate, is moving along. We also moved out 2 other bills, Senate bills, all trying to include in the statutes the new pronouns and make sure that we're using proper language. And there are some parts of the statute that we need to go through and make sure that we are using proper language and consistent with what we have in 384. So if 384 passes and the other 2 bills, which are SB 109 and SB 110, if we move all those out, in conference committee, we may change the focus of this task force and as recommended by the judiciary so that it would focus on other portions of the Uniform Parentage Act that are not addressed in HB 384, including assisted reproduction and surrogacy, as well as identify all the other places in Hawaii revised statutes that need to be changed to include the same language that we have in those 3 bills. So I want to have that flexibility to do in conference committee. So that's my recommendation. Move out SB 944 with an HD2, making that 1 amendment on page 2 and changing the effective date to June 30th, 3000. Questions or concerns, members? Representative Ganadin.
Chair, I think we heard some fairly heartfelt testimony from individuals who don't have parentage that we would describe, I suppose, as the bill describes as cis heteronormative, and there's individuals who come from adoptive families. I think that if we were to pass it out as is, we would need to take their suggestions and add into the task force someone that could advocate from their perspectives.
Well, I appreciate that. I think in the language of the bill, it says the members shall include a mental health professional familiar with post-adoption experience, an individual with personal knowledge of adoption-related health and medical issues, and any other member as recommended by the task force. So it has some pretty broad language in there. It doesn't specify what was requested in the testimony, but until, in conference committee, we should keep your recommendation in mind, so that if we in fact do narrow the focus, then that would be the opportunity to add members into this. That would be my suggestion. So I still would like to move it out without adding those additional names, because again, we're not quite sure what the focus will be for this task force. And as we modify it, we could also specify members.
I understand, Chair. Thank you.
Thank you for that suggestion. Any other questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 944 SD1 HD1 with further amendments. Any reservations or noes? Seeing none, your recommendation is adopted.
Thank you. Next measure, Senate Bill 586. This is another in a series of bills on noisy mufflers. This is not as easy an issue to resolve as one would think. And there are some, certainly on this committee and in the House, that also share that skepticism that this and other measures may not actually be successful. So I'm moving this forward, but with skepticism, and we'll make sure that it will be very discerning in conference committee about this, but I would like to make some changes to it before moving it on. On page 4, I would like to delete the changes that were made in Senate Draft 2, which made it a petty misdemeanor. I think that's too much. I would like to revert back to the original language, which has it being a violation. Right now, it says, whoever violates this section shall be fined not more than $100. I would change that 100 to 500, but it shall remain a violation only, not a petty misdemeanor. And then on the other, page 5, this is section 4 of the bill, which was changed in the SD2 to make violation of that section a petty misdemeanor. I disagree with that as well. I think that's too much. I'd like to delete those changes so it remains a violation, and that right now it says the violation shall be not less than $25, no more than $250 for each separate offense. I'll put the max at $500. And I want to change the effective date to June 30th, 3000. And then take it to conference committee. And I would welcome comments and criticisms from members because that'll help me decide who might be the best people to help me in the interim to figure out how to address this issue, because it's not going away. So that's my suggestion, to move this out with an HD1, make those changes on pages 4 and 5, change the effective date to June 30th, 3000. Questions or concerns, members? Representative Ganadin.
Chair, with respect, I mean,
sure.
Similar to the previous discussion that we had around cutout mufflers or no mufflers on either two-wheel vehicles or regular cars. There's not much of a discussion here in this bill around like how loud we're even talking. There's no discussion about like, you know, a perceived loudness, decibels, who would rate it, how the officers would rate it. That there's far more questions than we have answers to. So I'll just vote with reservations for now.
I appreciate that, and your comments are duly noted. And I think you might be very helpful in figuring out what to do during the interim. Well, we'll work on that together. Other questions or concerns? And please speak up. It's not like I'm going to assign you this over the interim if you speak up, but just. That's what I heard. But I would welcome your input, because we have to resolve this issue. Otherwise, it's going to keep coming back. And so I'd like help on that, only if you're willing. Okay. If there's no other questions, recommendation is to move out an HD1 with the changes on page 4 and 5, an effective date June 30th, 3000. Vice Chair for the vote.
Voting on Senate Bill 586 SD2 with amendments, noting the reservations of Representative Ganadin. Any other reservations or noes? Seeing none, your recommendation is adopted.
Thank you. Look forward to working with everyone on that measure. Senate Bill 410 relating to expungement. After reading the testimony and discussing with the introducer, I want to move this out and make some amendments. So it'll be a House Draft 2, make some technical amendments, and I'd like to incorporate the prosecuting attorney's testimony, and then to address some of the judiciary's concerns, but not all of them. I'd like to delete subsection E of section 2. So that's on page 5. And delete section 3. But I'm going to retain section 4 and 5. So I think that should address the issues in large part what the judiciary had. They'll still have to do some work on this, but I think it would achieve the goals that the introducer is hoping to achieve and the advocates are hoping to achieve. And we'll keep the July 1st, 2025 effective date so that the judiciary has time to work out the details of it. That's my and some technical amendments as well. That's my recommendation. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 410 SD1 HD1 with further amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. I should say in the standing committee report on that last measure, I'd like to make sure that we include the request from judiciary that they need $70,000 to update their databases to accomplish the goals of that measure. So we'll include that comment in the standing committee report. Okay, moving on to the next measure, Senate Bill 921. After careful evaluation of all the testimony on this, I feel like that this is reasonable. So I would like to move it forward as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 921 passing as is. Any reservations or noes? Seeing none, your recommendation is adopted.
Thank you. Next, on Senate Bill 1468, relating to the right of entry for professional surveyors. You'll remember, members, that we passed out a similar bill, House Bill 1241, which is no longer alive. And so this bill, Senate Bill 1468, SD2 HD1, is the one I'd like to work with. But I want to make it consistent, and there's only one sentence that's missing in the Senate bill that I would like, that was in our House bill that I want to put in the Senate bill. So that would be on page 4, line 3. It would add a new sentence after their period, that's line 3, page 4, and the new sentence would be, if the landowner or occupier of the adjoining lands does not make a timely objection, the land surveyor and any assistant under the direct supervision of the land surveyor shall be authorized to enter the adjoining lands pursuant to this section. And then in our bill, we always refer to the land surveyor and any assistant, or any assistant under the direct supervision of the land surveyor. I'd like to have that addition, where appropriate, in the Senate Bill 1468. So those are my recommendations. We'll keep the defective effective date so that we can take this to conference, and CPC committee and ours can work on that together. And there will be some technical amendments as well. So that's our House Draft 2 I'm proposing. Any questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1468 SD2 HD1 with further amendments. Any reservations or noes? Your recommendation is adopted.
Thank you. Senate Bill 1196. It's amazing. This is the fourth hearing, and there's been no testimony on this at all. I checked with the governor's office to see if they had any issues or comments or concerns, and did not hear any. I would like to take this to conference committee. I'll keep bugging the powers that be up on the 5th floor to see if there's any concerns. But I want to keep the defective effective date to take it to conference, and if there is concerns, we can work with them there. So I would like to move it out as is. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1196 SD1 HD1 passing as is. Any reservations or noes? your recommendations adopted.
Thank you. Senate Bill 415, after discussion with the Labor Chair in the House, my recommendation is to move out of House Draft 2, change the effective date to effective upon approval, and move it out. Questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 415 SD2 HD1 passing with amendments. Any reservations or noes? Seeing none, your recommendations adopted.
Thank you. Final measure, Senate Bill 1057. I am convinced, really, by the compelling testimony that this is a good idea. It won't solve all the problems as in pay equity, but it will certainly help. And I would refer members to a Harvard Business Review article entitled Research, the Complicated Effects of Pay Transparency by Oblage and Zenger, February 8, 2023. A useful recent compilation of this issue, and I think I would agree with them that this is a positive step. I want to note that the last committee asked us to consider whether job performance should also be a factor in a job's pay rate. I checked with the chair of the Labor Committee, and he said that I asked him what he wanted me to do with that comment, and he said, oh, don't worry about it. I checked in the statutes, and we're covered. So we don't have to do anything with that. And I think, as mentioned, that when the performance is evaluated, it's after the person is hired, and that determines how you manage that employee going forward. So I think we're okay not including anything in here about performance in this bill. So my recommendation is just to make technical amendments, keep the defective date, move it out as a House Draft 2. Questions or concerns, members? If not, oh, yes, Representative Ganadin.
Sorry.
No, don't apologize.
Keep talking. I didn't read a Harvard Business Review document, Chair. Oh, wow, I get to read it in my off time. But, you know, with respect to the chamber, in Hawaii, people are known to work several jobs because the positions that they work are underpaid as compared to the same position usually on the continent. And it's really not that difficult in a listing to say how much a job pays. I believe the state does it by statute. There's issues regarding, you know, younger people who want to work, who decide not to work. I think they call it quiet quitting. It's a sociological trend happening throughout the Western world. So I think we need to start telling people how much a job pays. Thank you.
Yes, I agree. I agree. And I'll be happy to send that Harvard Business Review article to other members of the committee for your reading pleasure. Any other questions or concerns? Yes, Representative Kong.
Thank you, Chair. I believe that Section 2 will actually handcuff small businesses, and even performance, as you mentioned, does make a big difference when we're hiring. So even like the testifier, Ms. Evans says, you know, you want to give them a raise within that salary range. That's not necessarily true. We may give them way more because we don't want to lose this good person to the competition, and vice versa. There's so many things, as in the testimony from Chamber, NFIB, and retail merchants, so forth. I'll have to be voting no.
I understand, and I appreciate your experience as an employer. My reading of this is that it would not prevent someone from getting a raise after they're hired that may extend beyond the pay scale they were shown when they were hired. But that's my reading of it. But I will keep that in mind as we go forward, and I'd like to talk to you more about it to understand.
Okay, thank you, Chair.
Thank you very much, Representative Kong. Other questions or concerns, members? If not, Vice Chair for the vote.
Voting on Senate Bill 1057 SD2 HD1 with further amendments, noting the no vote of Representative Kong. Any other reservations or noes? Seeing none, your recommendation is adopted.
Thank you very much. There being no further business before this committee, we are adjourned.